Shilpa Mehta of the Feldstein Family Law Group. Today I'm discussing with you the issue of child support for adult children. Most cases are clear-cut. If a child is 18 but still in school full-time, support will continue. But what about the 20-year-old adult child still in high school? The support recipient wants support to continue until the child has finished high school and continues on in post-secondary education, college, university, full-time school. Most 20-year-olds are either in post-secondary, working, or doing nothing. Support continues in the first case and stops in the latter two cases. No big guessing game there. Part-time school sometimes poses a problem, but that is not my focus for today. I care about the 19 and 20-year-olds still struggling through high school. Not the victory lap kids who need to improve their grades because they need to get into university or need extra time to plan their futures, but are making the correct decisions to stay in school since the loss of OSC or grade 13. I'm referring to the 19 and 20-year-olds that, due to a learning disability, are taking longer to complete their high school education. Some have stayed in their high schools and others have opted for alternative learning education programs recognized by the Board of Education. Children who present with learning disabilities, whether verbal or nonverbal, often struggle through their elementary and high school. Course loads are modified based on individual education plans, IEPs. Some children have IEPs that look like a shopping list and others have less detailed ones. To obtain an IEP, almost always have a psychoeducational assessment would have been completed by the school, by a hospital based on program or privately. Waitlists are unacceptable for the funded testing and the private assessments are costly. The same IEP is often adjusted annually and relied upon so that the child can obtain resources within the school in their regular class, in community-based classes, or withdrawn from the class for various parts of the day. Even once a child has an IEP, the public schools often do not have sufficient funding for sufficient resources and the child still lags. These are the children to whom I refer. When a child has a modified program and is required to take fewer courses or credits per semester, he or she will undoubtedly graduate later than his or her peers. But that is not all. We are dealing with some children who frankly feel stupid. The lack of motivation to work at the program or even attend school due to difficulties presented in class work. These children often skip classes, have poor attendance records, and some have failing grades. Are they trying? Put yourself in their shoes. The parents really need to discuss these issues early on, as early as when a child is first identified with a learning disability and again at the time of separation. If the latter happens first before identification, the parents need to speak about it. If they cannot, then the payer should make him or herself aware of the child's IEP through consultation with the school. To say 10 years later, I did not know that my child had a learning disability because their mother or father didn't share that information with me is no excuse. Be in touch with the teachers, doctors, etc., even the other spouse if they have sole custody. The parent residing with the child who has the learning disability has a big job ahead of them or her, educationally and socially. If the other parent maintains a close relationship with this child, he or she will understand and want to make the right decisions for his or her child. The money paid monthly to support the recipient is needed. The child is having difficulty, more difficulty than their peers at finishing school, struggling through what others have identified as their best and easiest years of their life. Whatever the quantum of child support paid, whether it's $1,000 or $500 per month, payable until the child finishes school, can have a big impact on the support recipient who would otherwise have to support this child on his or her own. The goal is to allow the child to finish school at whatever age he or she can continue on into college, trade school, to find a job catered to his or her needs. If the child continues his or her education in post-secondary school or trade school, he or she would still be supported. If you have more questions about this or any other legal issue, please contact us to schedule a consultation at 905-415-1636 or visit our website at www.separation.ca. Thanks for watching.